Page 286. The FBI experts who examined this issue for us stated that historical Tor exit node data conclusively disproves this white paper's allegation in its entirety. Moreover, the FBI experts further explained that the construction of the Tor network makes the arrangement described in the white paper impossible. Indeed, they added that even if true or possible, using the Tor network in the manner alleged in the white paper would result in worse anonymization and security than simply using Tor in its default configuration. Rather than allowing for clandestine communication, the setup described in the white paper would create a static proxy with a known endpoint that could be more easily traced with traffic to the relatively small number of guard nodes, which would allow for the identification of the true source IP much more easily than using a randomly selected node for each connection as the Tor system is designed to do. In simpler terms, the FBI experts told us that using a Tor exit node in this manner described by the white paper would make a secret communication channel much easier to find, not harder. And they further noted that although it is entirely likely that one or more users at some time connected to both Spectrum Health and Alpha Bank using Tor, and may have even come through the same exit node, this possibility in no way indicates any kind of correlation because of the deliberately random nature of Tor routing. We also tasked the same FBI experts to review the white paper on Yodaphones that Sussman provided to another government agency on behalf of Jaffe. This white paper stated that there was an unusual Russian phone that was operating on Trump Organization networks and in the executive office of the president. Its claims were based primarily on DNS resolution requests from the domains client.yoda.ru and ymaxclient.yoda.ru from July 23, 2016 through January 15, 2017 from Trump-affiliated networks, coupled with the assertion that such Yodaphone resolution request activity was rare in the United States. However, the FBI expert examined historical DNS query data for the yoda.ru domains for the same time period as that analyzed in the white paper. Indeed, they examined data that the white paper researchers also had access to. In doing so, the FBI experts determined that contrary to the claims set forth in the white paper, the DNS query data actually indicated that resolution requests for these domains were not at all rare from U.S.-based IP addresses as compared with other countries. These experts further observed that the DNS query data used to support the white paper claims was deliberately filtered to select only those organizations in the United States with ties to Trump. Page 287. In sum, as a result of our investigation, the FBI experts advised us that actual data and information on Yodaphone resolution requests directly undermined or refuted several conclusions and inferences included in the Yodaphone white paper. Prosecution decisions. We identified evidence that certain individuals and entities promoted the Alpha Bank and Yodaphone allegations to the intelligence community. We examined the validity of the allegations, conducted the technical analysis, and assessed the data and information that was provided to the FBI and CIA. We examined this evidence in considering whether the activities by these individuals and entities, as well as government officials, violated any criminal statutes. In particular, the investigation examined whether these individuals and entities either on their own provided or conspired with others to provide false or misleading information to the intelligence community. First, and as noted above, we identified certain statements that Sussman made to the FBI and the CIA that the investigation revealed were false. Given the seriousness of the false statements and its effect of the FBI investigation, a federal grand jury found probable cause to believe that Sussman had lied to the FBI and charged him with making a false statement to the Bureau in violation of 18 U.S.C. Section 101. Ultimately, after a 2-week trial, a jury acquitted Sussman of the false statement charge. We also considered whether any criminal actions were taken by other persons or entities in furtherance of Sussman's false statement to the FBI. The evidence gathered in the investigation did not establish that any such actions were taken. Second, our investigation uncovered evidence of actions taken by individuals and entities with ties to the Clinton campaign to promote the Alpha Bank and Yodaphone allegations to the intelligence community and Congress. We evaluated whether any of these individuals made a false statement within the meaning of 18 U.S.C. Section 101 and whether admissible evidence would be sufficient to obtain a conviction for such an offense. We also considered whether actions taken by certain persons could have implicated further election laws. We concluded that the evidence was not sufficient to obtain and sustain a criminal conviction. We examined as well whether the actions and conduct of Sussman and various other persons in advancing the Alpha Bank and Vodafone allegations established a conspiracy to defraud the United States in violation of 18 U.S.C. Section 371. Ultimately, we concluded that our evidence was not sufficient to obtain and sustain a criminal conviction. We did not obtain admissible evidence likely to meet the government's burden to prove beyond a reasonable doubt that the individuals acted willfully, example, with knowledge and the illegality of their conduct. With general knowledge of the illegality of their conduct. We faced, page 288, we faced significant obstacles in obtaining evidence because many of the individuals and entities involved invoked multiple privileges, including the attorney-client and Fifth Amendment privileges. Third, we examined the FBI's actions in response to the Alpha Bank and Vodafone allegations. We assessed whether any FBI or federal official conspired with any other persons in promoting the Alpha Bank allegations to damage the Trump campaign or benefit the Clinton campaign. Our investigation did not find any evidence that the FBI official or employee knowingly and intentionally participated in some type of conspiracy with others to promote the Alpha Bank allegations to cause the FBI to open an investigation. Certain FBI officials, however, declined to be interviewed on the matter, and others professed a lack of recollection of it. Finally, we considered the conduct of the third parties and other government officials regarding actions taken following the election that involved the continued promotion of the Alpha Bank and Vodafone allegations to law enforcement and other government bodies. We did not, however, develop sufficient evidence to charge false statements or conspiracy crimes in connection with any intentional misrepresentations in this regard because it was unclear in numerous instances when particular data searches involving the alleged activity at the EOP were run and when specific data files came into possession of the relevant persons. Example, whether such data was searched or identified before or after materials were received by the CIA or Congress. In addition, because of the protections of the attorney-client privilege and other impediments, we were unable to determine with precision or certainty who authored each of the relevant white papers. Accordingly, we did not charge any individuals with knowingly providing false information to the government in connection with the Alpha Bank and Vodafone allegations. Observations. In making the observations that follow, we are mindful of the benefits hindsight provides and the hazards of possibly being unfair to individuals who are called upon to make decisions under real pressure and the unprecedented circumstances. That said, the objective facts show that the FBI's handling of important aspects of the Crossfire Hurricane matter were seriously deficient. Some FBI employees who were interviewed by our investigators advised that they had significant reservations about aspects of Crossfire Hurricane and tried to convey their misgivings to their superiors. Others had doubts about the investigation, but did not voice their concerns. In some cases, nothing was said because of a sense that there had to be more compelling information in the position of those closest to the decision-making center of the case than had been made known to them, and there were still other current and former employees who maintained that they did the best they could to make reasonable investigative steps and acted within the FBI's various policies, procedures, and guidelines. As the more complete record now shows, there are specific areas of Crossfire Hurricane activity in which the FBI badly underperformed and failed, not only in its duties to the public, but also in preventing the severe reputational harm that had been befallen the FBI as a consequence of Crossfire Hurricane. Importantly, had the Crossfire Hurricane actors faithfully followed their own principles regarding objectivity and integrity, there were clear opportunities to have avoided the mistakes and to have prevented the damage resulting from their embrace of seriously flawed information that they failed to analyze and assess properly. Page 289. As described in Section 4, both the OIG and the FBI's Inspection Division have reviewed aspects of the Crossfire Hurricane investigation into possible collusion between Russia and the Trump campaign and the FISA applications targeting Carter Page. The OIG also conducted a more limited audit of the accuracy of 29 FISA applications that were not connected to Crossfire Hurricane. In 2020, the Department and the FBI provided the Privacy and Civil Liberties Oversight Board, PCLOB, 19 of the 29 applications reviewed by the OIG. The PCLOB is an independent agency with the executive branch that was established by the 9/11 Commission Act of 2007. The board's primary mission is to ensure that federal efforts to prevent terrorism are balanced with protecting privacy and civil liberties. The 19 applications were directed at counterterrorism targets and Adam Klein, the former chairman of the PCLOB, reviewed the 19 applications. Following the OIG's review and audit, both the Attorney General and the FISC directed that a number of changes be made. Outside commentators have also recommended numerous changes. In the FISA reform proposals put forth by various individuals and groups, there is division between those that would make all or many FISA surveillance more difficult or prohibit certain types of surveillance altogether, and those that focus more specifically on the issues raised by the page applications. Making our observations, the office considered but did not include proposals that would curtail the scope or reach of FISA or the FBI's investigative activities. We are concerned about the impact of such proposals in a time of aggressive and hostile terrorist groups and foreign powers. The FBI's priorities include protecting the United States against national security threats. Inevitably, that involves pursuing some targets and investigations that end up yielding few results. The OIG review of the September 11th attacks noted that the FBI failed to use the FISA statute fully, and that in its investigation of Zacarias Moussaoui, a potential 19th hijacker, the deficiencies included a narrow and conservative interpretation of FISA. More recently, for reasons that may include the COVID pandemic, the impact of the page FISA applications, or changes in government priorities, the number of FISC orders using certain FISA authorities repeatedly had declined sharply, from 1,184 to 430 over a recent 4-year period. Page 290. Former Assistant Attorney General David Criss has said that in amending FISA, you are doing surgery on a very complicated thing. He went on to say that may sound trivial, but it's actually very important for national security. Moreover, if amendments are not approached from a long-term perspective. He says, I worry that in that not too distant future, we may find ourselves on the other end of the familiar national security pendulum swing, reviewing a new Inspector General or other report, this time criticizing the Justice Department for the proliferation of red tape or other restrictions and the failure to stop an attack or other grave hostile acts committed against our national security. Senator Graham expressed the same thought succinctly. I'd hate to lose the ability of the FISA court to operate at a time probably when we need it most. Thus, we first discuss below the prior review that the OIG conducted of the FBI handling of the Robert Hansen investigation, focusing on problems that appear both in that investigation and Crossfire Hurricane. We then turn to measure to assist in the full and complete consideration of politically sensitive investigations and make FISA applications more understandable and complete for the officials and judges to review and approve them. We conclude with a discussion of bias and improper motivation and suggest one possible FBI reform for consideration by the department. We do not try to review all the many changes that have already been made, but rather seek to build on them. Section A. The OIG's prior evaluation of systematic problems in the FBI's counterintelligence program, Robert Hansen. Robert Hansen was the most damaging spy in FBI history. For more than 20 years, while he was assigned to the FBI's counterintelligence program, Hansen betrayed the United States and gave the KGB enormous amounts of highly sensitive information, including the identities of dozens of human sources, some of whom were subsequently executed by the Soviet Union. The OIG conducted an extensive review of the FBI's failures to deter and detect Hansen as a mole and concluded that Hansen did not escape detection because he was a master spy or was extraordinarily clever and crafty, rather because of long-standing systematic problems in the FBI's counterintelligence program. Page 291. For many years, the FBI focused on a specific CIA employee as the potential mole. Although its initial focus may have been reasonable, as time went on, it states, the FBI should have seriously questioned its conclusion that the CIA suspect was a KGB spy and considered opening different lines of investigation. The squad responsible for the case, however, was so committed to the belief that the CIA suspect was a mole that it lost a measure of objectivity. While FBI management pressed for the investigation to be completed, it did not question the actual premises underlying it. One of the OIG's recommendations for the FBI's counterintelligence program in the Hansen matter was that supervisors must guard against excessively deferring to line personnel and must ensure that the department is properly briefed on the strengths and weaknesses of potential espionage prosecutions. A more cooperative relationship between the counterintelligence division and the department, the OIG explained later, would make it more likely cases against analytical and investigative judgments in counterespionage cases will be adequately scrutinized. Other recommendations similarly concerned greater involvement for department attorneys, including a large oversight role in ensuring the accuracy and fairness of factual assertions in FISA applications, and direct access to the case agent and the source information relied on in the application. While considering Crossfire Hurricane, some of the OIG's recommendations continue to be relevant, particularly by analogy. Numerous reports clearly state that Russia was trying to influence the 2016 presidential election. Page 292. This was also the prevailing view of the media, and it was widely accepted through open-source reporting at the time that Russia was to blame for the unlawful intrusion into the DNC servers. One of the chief errors from the start of Crossfire Hurricane was the poor analysis the FBI brought to bear on the critical pieces of information that it had gathered, as well as an over-reliance on flawed or incomplete human intelligence that only later was found to be plainly unreliable. In July 2016, the FBI received the most damaging of the Steele reports, but mysteriously and unfortunately, these reports do not appear to have made their way to the Counterintelligence Division for analysis until after mid-September. Later in July, Australia provided the information from Papadopoulos to U.S. authorities. The FBI then appears to have formulated a hypothesis that the Trump campaign, or someone associated with it, was working with the Russians. Neither the Crossfire Hurricane opening EC nor those responsible for the investigation in the Counterintelligence Division or upper management, however, appeared to have recognized the crucial need to analyze and then assess the actual ambiguities in Papadopoulos' statement to the Australian diplomats. Instead, the FBI immediately opened a full investigation, an investigation that clearly had the ability to affect an approaching presidential election. Indeed, executive management at the FBI and its Counterintelligence Division appeared to have taken the paragraph 5 information at face value in opening the matter as evidenced by opening EC, citing the paragraph 5 information as essentially the sole basis for opening a full investigation on unnamed members in an ongoing presidential campaign. Then, when the Steele reporting finally was received by Crossfire Hurricane personnel in September 2016, it was immediately exploited with no verification of its sensational allegations and used in support of its initial request for FISA authority. The Steele reporting would eventually fall apart, but not before it had been continuously adopted by the FBI as supportive of its underlying theory regarding collusion. The intelligence community's analytic standards say that the analysts, quote, must perform their functions with objectivity and employ reasoning techniques and practical mechanisms that reveal and mitigate bias. In the Hansen investigation, the squad responsible for the case was so committed to the belief that the CIA suspect was a mole that it lost a major objectivity and failed to give adequate consideration to other possibilities. Page 293. The SSCI Russia report observed that the FBI's analysts should endeavor, quote, to check assumptions underpinning FBI operations to apply the rigor of intelligence analysis to the assessments and confidential human sources and to create a culture where questioning previously held assumptions is acceptable and encouraged, end quote. The office concurs with this recommendation. Apart from the analytical integrity, in seeking FISA authority in Crossfire Hurricane, investigators withheld key pieces of information from the OI attorneys. The OI attorneys are responsible for ensuring the accuracy and fairness of the information presented to the FISC, an impossible task without being provided the relevant information. Both the OIG's review and this review highlight the omissions, errors, and misstatements by FBI personnel, including the withholding of a significant exculpatory statements that should not have occurred had the Crossfire Hurricane investigators considered and treated the department lawyers as full partners. Rather, the Crossfire Hurricane reflects a struggle by OI to obtain straightforward answers about Steele's possible bias and leaks to the media and Page's relationship with another government agency. Nor was OI told about the significant differences between the Steele reports and the statements Danchenko made to the FBI. In the follow-on Hansen Progress Review, the OIG quoted a department official as saying that the department, quote, still has the occasional fight with the FBI to get full access to information, particularly information pertinent to the reliability of sources relied on by the FISA applications, end quote. Crossfire Hurricane investigation showed that, regrettably, these struggles for accuracy and transparency were still occurring in 2016. Moreover, it is certainly to be hoped that with the new post-Page requirements of the Sensitive Investigations Memorandum, the new guidelines governing the FBI's use of human sources, and other significant policy changes, there will not be a recurrence of the serious errors identified by the OEG, the Inspection Division, and our investigation. Absent continual reinforcement by FBI leadership of the need for integrity, accuracy, and objectivity in following these requirements, however, such is not a certainty. Section B. FBI investigations. The New York Counterintelligence Investigation. When the New York Field Office opened a counterintelligence investigation of Page in April 2016, at a time when he was a foreign policy advisor to the Trump campaign, the investigation likely should have been treated as a sensitive investigative matter because of Page's role in the campaign. The Attorney General has since addressed this issue in a desirable, though slightly different way. The Attorney General must approve any investigation of a senior presidential campaign staff member or advisor. A footnote explains that this includes any person who has been publicly announced via a campaign as a staffer or member of an official campaign advisory committee or group. Page 294. Predication of Crossfire Hurricane. The FBI opened the Crossfire Hurricane investigation as a full investigation to determine whether individuals associated with the Trump campaign are witting of and or coordinated activities with the government of Russia. As described in Section 3, the standard for opening a full investigation is an articulable factual basis for the investigation that reasonably indicates that an activity constituting a federal crime or a threat to the national security is or may be occurring, and the investigation may obtain information relating to the activity. The information that the FBI learned in July 2016 was that a Trump campaign advisor had suggested to the Australian diplomats that the campaign had received some kind of suggestion from Russia that it could assist the campaign. The OIG review found that the FBI met the requirements of the AGG DOM because the articulable factual basis standard for opening the investigation is a low one, and the information from Australia, at least when considered along with what was known about Russia's efforts to interfere with the 2016 U.S. elections, met that standard. We are not confident, however, that this is the case. Our investigation gathered evidence that showed that a number of those closest to the investigation believed that the standard arguably had not been met. For example, both Supervisory Special Agent 1 and UK LAT 1 described the predication for the investigations as thin. Even Stroke, who both drafted and approved the opening EC, said that, quote, "there's nothing to this, but we have to run it to the ground," end quote. Stroke's view would seem to dictate the opening of the matter as an assessment, or at most as a preliminary investigation. In any event, there are a number of other reasons to be concerned about the predication of Crossfire Hurricane. Apart from the need to meet the standard of the AGG DOM for opening a full investigation, Executive Order 12333 requires the use of the least intrusive collection techniques feasible. FBI policy says that, quote, when First Amendment rights are at stake, which they clearly were in a major party political campaign, the choice and the use of investigative methods should be focused in a manner that minimizes potential infringement of those rights, end quote. Moreover, the FBI will apply best judgment necessary to achieve an objective. To assist FBI agents with their judgments, decision-making, and the need to employ the least intrusive means, the DIOG includes precautions when opening and conducting investigations in order to, among other things, encourage careful evaluation of facts and circumstances, as well as to assess risk before proceeding with any investigative activity. Page 295. In implementing these standards, the FBI could have taken one or more of the following sensible steps. Under the least intrusive standard, rather than opening an investigation with a broad scope to determine whether individuals associated with the Trump campaign are witting of and or coordinating activities with the government of Russia, the FBI should have focused, at least at the beginning, on Papadopoulos, the alleged source of the information from Australia. On the other hand, in paragraph 5, information was not only connected to Papadopoulos, but also to the campaign as an alleged recipient of some kind of suggestion from Russia. Under the FBI's guidelines, the investigation could have been opened more appropriately as an assessment or preliminary investigation. The FBI investigations opened as preliminary investigations, short of full investigations, include time limits and a narrow range of authorized techniques to mitigate risk and avoid unnecessary intrusion. If necessary and appropriate, a lower level of the investigative activity may be escalated under the guidelines by converting to a full investigation with a supervisory approval. In the subsequent investigation of Page under the Crossfire Hurricane umbrella, the FBI could have used additional, less intrusive techniques before seeking authority to conduct electronic surveillance under FISA. The paucity for information collected on key aspects of the Page's activities would support such an approach. Regardless of an investigator's preference for any of these steps, there are now additional requirements that apply to the opening of an investigation like Crossfire Hurricane. The Sensitive Investigations Memorandum requires the Attorney General to approve the opening of such an investigation. That is, an investigation like Crossfire Hurricane should require a concurring decision by the Department rather than any one component or entity seems appropriate. We also believe that the proposal described below in E for an identified department official to challenge all stages of a politically sensitive investigation would be another valuable way of addressing concerns about the opening, continuation, and intrusiveness of an investigation like Crossfire Hurricane. Opening of individuals' investigations. The FBI opened full investigations of Papadopoulos, Page, Flynn, and Manafort in August 2016 as part of Crossfire Hurricane. Again, in addition to the requirements of the AGG-DOM and the DIOG, the approval requirements in the Sensitive Investigations Memorandum now would apply to these. The proposal in Section VE would also potentially apply to them. Page 296. Compartmentation. Unlike most FBI investigations, which are managed from FBI field offices, Crossfire Hurricane was managed from FBI headquarters. The information it collected was not shared with or available to others in the FBI, including as described above, the Directorate of Intelligence. UIG review says that because the information being investigated related to an ongoing presidential election campaign, the Crossfire Hurricane case file was designated as prohibited, meaning that access to the file was restricted and viewable to only those individuals assigned to work on the investigation. Agents and analysts used covert investigative techniques to ensure information about the investigation remained known only to the team and FBI and department officials. Moreover, at least at times, even those participating in the investigation had limited information available. Supervisory Special Agent 3, who was tasked to supervise the Crossfire Hurricane investigators as a successor to Supervisory Special Agent 1, stated, contributing to the difficulties was how compartmentalized the investigation was, specifically the lack of information sharing between the intelligence analysts and the operational component. Even as the team lead, I only had access to limited information, and from the start of my temporary duty, I did not have a clear picture of everything going on in the investigation. I was managing a day-to-day operations of the case without having complete information. The investigation's compartmentation and its unusual structure as a headquarters investigation may have limited the amount of oversight that it received. In the past, NSA's collection of the international communications of U.S. citizens and groups was also highly compartmented. A Senate committee chaired by Senator Frank Church investigated this activity report. In 1969, NSA formalized the Watch List program under the code name Minaret. The program applied not only to alleged foreign influence on domestic descent, but also to American groups and individuals whose activities, quote, may result in civil disturbances or otherwise subvert the national security of the U.S., end quote. At the same time, NSA instructed its personnel to restrict the knowledge that NSA was collecting such information and to keep its name off the disseminated product. Page 297. The report found that NSA placed more restrictive security controls on Minaret material than it placed on other highly classified foreign intercepts in order to conceal its involvement in activities which were beyond the regular mission. In possible contrast to the FBI, the CIA may not have compartmented some of the information that it had. The office learned that at one point from Director Brennan that there was no effort at the CIA to restrict information because it was potentially embarrassing for Hillary Clinton. Obama just wanted the right people involved. In combination, an unusually the compartmented investigation bearing on politics will always involve risk, especially when it is the subject of significant media attention. In any event, in opening and conducting a sensitive investigation, the FBI should consider ways to balance the need for secrecy against the need to have a full and informed evaluation of the case. Leaks can cause great harm, but so can failure to understand the information collected or to take appropriate investigative steps.